Okay, thank you, Josh. And I think as we normally do before we proceed, I want to open up the 253rd meeting of the Municipal Police Training Council. And with that, I would ask Chief Parisi if he would lead us in a Pledge of Allegiance. If we would all stand, please. Go ahead, Chief.
There we go. I pledge allegiance to the flag
To the flag
of the United States
of
of
the States of America,
and to the republic
which
for which
is
it is one nation, under God, indivisible, with liberty and justice for all.
Thank you. If we could all just remain a moment of silence for those that we've lost in public safety and those serving in the military at this time. Just a moment of silence, please. Thank you very much. Okay. Okay, here we are with our virtual meeting again. We have 4 voting members, so we can proceed. A couple of things that I want to mention to the members of the council is that when it comes to making a motion, we need to read that motion out loud. And then when it comes to voting, I will be doing a roll call vote on each time we do a motion per the rules of a virtual meeting. So with that, we do have 4 vacancies on the council at this time. 1 sheriff, 1 chief, the member of the NYPD, and member of the state police, normally the state police superintendent. I appreciate Lieutenant Colonel Rick Allen being on this morning. So thank you. The agenda is before us that has been sent out, and I would ask for a motion to adopt that agenda that's before us.
Bruce McBride, so moved.
Do I hear a second?
Second, John Clovis.
Okay, thank you. Chief Parisi, how do you vote?
Yes.
Dr. McBride?
Yes.
Dr. Clovis?
Yes.
And myself is a yes, so the agenda has been adopted. The 252nd meeting minutes, which were, the meeting was last December, were disseminated to everyone. And if there are no corrections or any amendments, I would ask that we entertain a motion to approve those minutes.
So moved. Bruce McBride.
Thank you, Dr. McBride. Second?
Tim Parisi.
Second, John Clovis.
Okay, second, Chief Parisi, thank you. Okay, how do you vote, Chief Parisi?
Yes.
Yeah, thank you. Dr. McBride? Dr. McBride, how do you vote?
Yes.
Okay, thank you. Dr. Clovis?
Yes.
And myself is a yes, so the minutes are approved from the 252nd meeting. Now we move into the action and approval items for a discussion. The first one is on the license plate reader model policy, an update on that. And Molly Bates will be our presenter. Go ahead, Molly.
If I could interrupt for 1 second, Sheriff and Molly, 1 second. I'd just like to note for the record that Chief of Training for NYPD, Kenneth Corey, is also on the call with us. Although not confirmed as a voting member, he's still here representing NYPD.
Oh, thank you very much. I did not, I would have recognized that. I didn't see him. I'm glad he's on too. Thank you, Josh. Go ahead, Molly.
All right, thank you. Morning, Chairman and members of the council. In 2014, the Mptc first adopted the license plate reader model policy. However, due to advances in technology and increased usage of LPRs, as well as an ongoing review of model policies within DCJS, OPS staff convened a panel to review and update this policy. The review panel consisted of representatives from the New York State Chiefs and Sheriffs Associations, New York State Police, New York City Police Department, New York State Archives, and the New York State Crime Analysis Centers. The members are listed on the PowerPoint presentation, and we thank them for their input on this project. In addition to the panel members, I want to take this opportunity to acknowledge Dan Nedwell from OPS for his work on this project. He's unable to be here today because he's instructing a defensive tactics instructor course happening this weekend, next week in Westchester. I'll move on to the actual policy itself. I'm just going to provide an overview of the recent updates. First, the overall format of the policy itself was amended. We wanted it to align with more recent policies, such as the facial recognition for appearance, consistency, and keeping in mind the constitutional and civil rights of citizens. So now it falls more in line with many of our other model policy formats. In the definition section, the definition of query log is now more detailed to identify the person making the query, as well as the specific information that is queried. And we've also added a definition for the agency LPR administrator. And then this definition explains their basic duties and responsibilities for the position. Amendments were made to Section 4, which is the permissible uses of the LPR, which is located on page 2 of the policy. Subsection B outlines the permitted uses for law enforcement, and we've added 3 new uses, and they are identifying vehicles with suspended or revoked registrations while on patrol, regulating parking areas, and monitoring access to secure areas. In subsection C, regarding the use of hot lists, emphasis was placed on requiring the officers to ensure that the most current hot list data has been uploaded. And this language covers both officers who have to upload the data themselves, or officers have to ensure that the system their agency system uploaded the data, because there's varying, based on agency size, the officers responsible for it. Some larger agencies, they have other staff that are responsible for that upload. And then subsection D outlines the LPR data sharing and dissemination, and amended language was added to ensure that data sharing or access adheres to permissible uses of this policy. And that's on page 3 of the policy. Moving on to section 5. This is a new section on prohibited uses and mirrors language used in other technology-based model policies, such as our facial recognition model policy and the body-worn cameras. Section 6, this covers the records part of the policy. It outlines the responsibilities of the agency administrator as well as the retention period. And I think this is where we saw some of more changes from the previous policy. The retention period was amended to a minimum of 1 year for all late reads, which was previously 20 years. Agencies can certainly extend the length of the data where there is investigative or prosecutorial value moving forward or in accordance with any statutorily defined timeframes. Additionally, the retention period for query logs was amended to 6 years to align with the New York State retention schedules from the New York State Archives. Before I move on, I do want to just discuss how we went from 20 years to 1 year, since it's quite a difference. Staff researched what other states and agencies are doing across the country, as well as panel feedback was used to determine the new retention period. And based on this, the 1 year minimum was the best fit, just based on the various sizes of agencies around New York State, as well as their storage capabilities. And additionally, should the council adopt this amended policy, the state archives will be working to update their public safety retention schedules to align with this model policy. It's kind of like they base their retention schedules on our guidance, so we can't yet, reference state archives until they update it, but they are certainly on board with making any necessary. And then the last section of the model policy is the training section. This provides the minimum standards of what officers should be trained upon and mirrors language from similar policies regarding technology. Basically, they just have to be trained on its use and, any sort of changes that occur with. So, any questions? Sorry if I went too quick.
No, thank you, Molly. The only concern that I had was that in some of the contemporary stationary systems have now gone to terminology calling them ALPR systems. I believe the A stands for automated or autonomous. I'm not exactly sure on a lot of the stationary systems, and whether that's something we have to be thinking about or just leave it the way it is.
Excuse me. So I think we discussed that ourselves, just because there are different, there's the stationary LPRs and then the mobile ones on the cars. And I think we addressed that in the definition of LPR. Let me just, in the beginning of the policy, when we define what the reader is, it's the technology uses the optical character recognition to automatically read license plate characters. So we our intention was to leave that broad to incorporate, to cover both the stationary and mobile devices.
Correct. That's what I was thinking. So I appreciate the fact you looked at that.
Sure.
Any other questions from council members?
This is Bruce McBride. I think these are good updates. Has there been any interest from other parties, such as the ACLU, on any of these updates?
There have not, we didn't specifically reach out, but based on the fact that we based it on our facial recognition model policy, which I believe they did have input on, we felt we were pretty good, especially with the prohibited uses section.
Thank you. And is there any compliance efforts that have to be taken on this, or is this something that each agency has to deal with?
It's agency specific. Nothing.
If I could just add, there is an audit portion of it, an audit aspect to it, Bruce, that maybe would reference some of what you're saying, Molly. I'm thinking that might, for the compliance piece, that might be of interest.
Thank you very much.
Molly, John Clofus, correct me if I'm wrong on this, but looking at the earlier policy, there was a confidentiality of information statement that had to be signed off on. Is that in the newer version of the policy also?
Are you referring to the MOU that was included with the old one? Is that you broke up? I didn't hear very well.
Oh, I'm sorry. Well, it's described as a confidentiality of information personal acknowledgement in the 2014 policy, and I didn't see the same language in the newer one. Can you hear me now?
Yeah, I can hear you. Was that? I have to look at the old policy just to see.
Yeah, it's on.
Dr. Clofus.
It's on the top of page 3.
Dr. Clofus, if you're referring to LPR data sharing and dissemination between agencies, is that what you're referring to?
I'm looking for it now. LPR users shall sign the confidentiality of information personal acknowledgement with respect to training completed and appropriate usage an access of LPR. Reading from the document.
I'm wondering, Josh, if the section under 6, the section that talks about sharing of information, and the fact that anybody who we share it with must comply with this model policy would address some of Dr. Focus's concerns.
It is section 6 that I'm looking at.
Yes, in that section, it talks about the fact that if you're going to share with others, you must have an agreement. I'm just trying to find the actual section portion of it, and the fact that anybody who you share it with must also comply with this.
In the new policy, it's on page 3, under sharing and dissemination, subsection D, under permissible uses. It informs us that any agency that shares the data with another agency or the individual requesting it for law enforcement purposes must adhere to all the policy and the permissible uses of the policy and the prohibited uses of it, and ensure too that it's in compliance with all federal New York State laws on privacy, confidentiality, and dissemination.
So but there's not a signature requirement of a form to be signed off on to do that.
Yeah, if I could just comment real quick, John. Some of that may have been, as far as that confidentiality, that agreement. I know the language used there was something that was used within the Crime Analysis Center program and through the e-Justice portal, where some facial recognition technology is used, but not all of it. There are independent systems used by departments from mobile and fixed reader systems throughout cities and municipalities. So that, I think the less, I mean, as far as a specific within a model policy, as far as that, I mean, anybody who goes through the e-Justice portal, for example, has to go through testing and certification process, confidentiality training, that type of thing. I would just add that in the policing world, for using of LPRs in criminal justice, and policing type of information, anybody who has access to that is going through standard, protocols with respect to, similar to sharing other police sensitive information. I personally, the language that was used in there to ensure compliance in a model policy with respect to, how it's used, permitted, impermissible uses, and in compliance with all, laws and privacy acts, was kind of a catch-all that we thought covered, it in general, because it's much more than just how it's deployed through the DCR, through the portal system. I don't know if that helps. I just figured I'd offer it.
Yeah. No, I think I understand you, but basically you're saying that there's a general agreement that is made in advance, but there's not a signature required specifically on LPR information.
Well, I can tell you specifically, there is specifically in certain places that I'm familiar with that run systems, but as a model policy, I mean, this is how it's handled specifically in certain jurisdictions that manage their own systems. Our main issue with respect to compliance as a statewide model policy would be to ensure that, laws are followed, permissible uses are followed, that type of thing, how they enact that within their own jurisdiction, and how they use it. I mean, you may just have, local uses, and they have to follow the law. So I'm not quite sure if or how best would be to fit something that specific into this particular policy, other than to say that people need to be trained properly. They need to know the law, follow the law, and the permissible and impermissible uses. So again, not sure if that's helpful. I think we're maybe a little bit, but I can tell you, to answer your question, for example, the Crime Analysis Center program, again, without going into specifics, other systems that I'm aware of statewide, from a training and compliance perspective, signatures are required for analysts and even police officers to sign.
No, I raised it now only because it was a noticeable difference between the current the 2014 policy and the current edition.
Correct. We can revisit that. I don't have the specific stuff in front of me to do a comparative analysis myself. I'm happy to look at that personally. I think the purpose of this was to update it and get it to 2021 and not whatever it was originally issued back years ago. And if you know, we're not in a level of compliance that you're, you know, comfortable with, the council's comfortable with, then, you know, it's entirely up to you to, you know, tell us otherwise, but I had to explore that one further.
Yeah, Mike, and if I could, I just want to join on what you were saying before. I think the difference between the 2014 and this one is we really did try to make it more of a model that can be used by broadly, which I know you referenced earlier, as opposed to the 2014, I think had a lot more tighter to the specificity of the CACs. So I think the fact that we were trying to make it something that could be applicable more broadly, the way we do with all of our model policies, kind of address that, but agree totally. If there's something you want to have us look at for further, we will.
I'm fine with it. Thank you.
Okay, thank you. John, you're okay then if we go ahead and take action on the updated policy today, and then they can take that other part? Okay, all right, very good. I would entertain a motion if a member would like to read that motion, please.
I'll be happy to read the motion.
Thank you.
The motion is to approve the updated license plate reader model policy.
Can I have a second?
A second, Bruce.
All right, thank you, Dr. McBride. All right, we will vote on this motion in second. We've already had our discussion, obviously. Chief Parisi, your vote?
Yes.
Okay, Dr. McBride? Dr. Klofus?
Yes.
And myself is a yes as well. So the updated policy has been approved. Thank you, Molly.
Thank you.
Next on the agenda is the human trafficking model policy update as well. And I believe, Josh, you're presenting on that.
Thank you, Chairman. Sure, I'll be happy to present on it. In terms of housekeeping, like we did with the LPR model policy, we went back and reviewed the human trafficking model policy as well for potential areas of updates and ways to enhance the training, ensure it's in line with best practices. The model policy was last updated in March of 2016. So it was ripe for another review. And as we reviewed it, we recognized that back in 2018, the penal law was amended to further define sex trafficking of a child. If you, in your packets, the LPR model policy is located in there, and I included an annotated version of the changes that were made to the human trafficking model policy. And if you turn your attention to page 1, in the definition section, you'll see that the sex trafficking of a child, the definition was added underneath of human trafficking in the model policy. Previously, it was not there, obviously because it wasn't defined in the penal law until 2018, and that definition basically removes the need for force, fraud, or coercion where the underlying prostitution involves a child less than 18 years old, and that child would be deemed a victim of sex trafficking even if he or she voluntarily agreed to the prostitution enterprise. And you'll also see in the bottom of that page, we footnoted the penal law reference. So we further define human trafficking amongst labor trafficking and sex trafficking of an adult, and to include sex trafficking of a child based on the change in the penal law. Turning your attention to page 5 of the human trafficking model policy, we expanded a couple footnotes. Again, these are very minor updates to the model policy, not as extensive or broad as were made to the license plate reader policy, but just to draw your attention to them. The footnote on page 5, the first footnote, makes reference to including social and legal providers being authorized to submit human trafficking referral forms. The previous model policy, law enforcement was only noted as being able to submit human trafficking referral forms. That has now changed. Social and legal providers are also authorized to submit referrals to DCJS and OTDA. And the second footnote and the last of the minor updates to this model policy are again on page 5. And this is to inform law enforcement that a victim of human trafficking is authorized to bring forth civil actions, including any damages and attorney fees on behalf of themselves against the perpetrators of human trafficking. So that New York State Social Services law has been added to the model policy as a footnote to inform law enforcement that in response to providing resources and assistance, law enforcement is aware that this also exists in social services law as an option for a victim of human trafficking to bring forth civil action against the perpetrator. Again, these are very minor updates to the human trafficking model policy. I certainly would entertain any questions that you may have in regards to this. And the other thing I'd like to mention is, I'll move forward to the slide. We, based on a meeting from December's meeting, we informed the council that we'd like to present the model policies and post them to the New York State public website. It was unanimous support from the council for us to begin posting the Mptc model policies and standards to the public website. We have since done that. There's multiple policies that have been posted. And in light of the license plate reader model policy being passed by the council, and if the council accepts these updates as well, we'll move forward and also post these model policies to the public website as well. And we'll continue to do a comprehensive review of all the older policies and ensure, again, they're in line with best practices before we post them. And obviously, we would bring them to the council for their review and consideration and adoption before they're posted. But I'll go back to the motion. If there aren't any questions, we certainly would like the council to consider approving the update to the human trafficking model policy as discussed.
Okay, thank you, Josh, for that information. Just one observation. I, for one, appreciate the fact that you're adding all those footnotes to, especially a policy like this. It's a complex policy, and to be able to have references to the sections of the social services law, especially that are applicable, is really important to writing policy for sure. So I think that's a good trend that we're doing and we're putting into these things. So that's just a good work on that. I think you need to know that it's appreciated. Any council members have any comments or concerns? Okay, I would entertain a motion on this, if one would read that, please.
Bruce McBride, to approve the updates to the human trafficking model policy.
Thank you. Second?
I second.
Okay, thank you. Okay, we have a motion and a second. I don't believe there's any further discussion. There is none, so Chief Parisi, how do you vote?
Yes.
Dr. McBride?
Yes.
Dr. Clofus?
Yes.
And I vote yes as well. Thank you, Josh, for that information. That model policy update is approved. Now we move on to the reality-based training instructor and recruit training All these are referenced to the COVID safety protocols, and Molly Bates is going to update us on that. Go ahead, Molly.
Thank you again. Good morning, everyone. You may recall in June of last year, the Mptc endorsed defensive tactics safety protocol for COVID-19 for academies, for guidance for academies to safely conduct defensive tactics training. Recently, as staff prepared to deliver a reality-based instructor training, we felt it was necessary to develop RBT-specific guidelines for both the instructor level course and the recruit training. All of the RBT guidelines are derived from the defensive tactics safety protocol that were previously developed and follow all CDC and New York State Health Department guidelines, the completion of a health screening prior to training, and the wearing of a face mask or a face covering when they're conducting the training. Both the instructor and recruit guidelines recommend all students be assigned their own training gear and will be responsible for its sanitization. If you recall too, the DCJS was able to purchase RBT gear for all of our academies about 3 or 4 years ago, so they already have that gear. Any shared equipment such as training weapons and props for scenarios will be cleaned both before and after use, and the cleaning supplies will be supplied by us, DCJS, for any DCJS hosted training, and then the sponsoring agency will be responsible for their cleaning supplies at the basic level. For group activities and scenarios, students from the same agencies should be assigned to the same group to limit any sort of spread. Specific to the instructor course, group assignments are required by the training. All groups and teams are established at the beginning of the training and remain intact throughout the entire course. All efforts will be made to keep members from the same agency together, and there's going to be no intermingling of the groups, and they will also have their own assigned classroom space to reduce contact and spread everybody out. Instructors' assignments for RBT will be similar to defensive tactics, where instructors will be assigned to a specific student group to limit exposure and will be assigned their own training gear as well. Lastly, I'd like to just take a moment to thank Mike Puckett from OPS for his work on this protocol. He's actually out instructing an RBT instructor course this week, so was unable to make the meeting. So these are pretty, they fall in line really with our DT protocol, but we just wanted to do some RBT specific notes. So open to any questions.
Yes, thank you, Molly. Well done. Obviously, we're trying to make an effort here for the safety of and the wellness of course of not only the recruits but the instructors as well, and then all the staff that are on location. So these are all important things. So I thank you. Does any council member have any questions or concerns?
Bruce McBride, this is just a comment. I think it's imperative that the academies have enough equipment, especially the personal protection equipment for all their students. I know it gets expensive, and I know that the Office of Public Safety has purchased much equipment for this purpose. But I can see, especially with some schools, that somebody could say, well, we don't have enough equipment and you got to share this, you got to share that. And that's just not acceptable in this day and age. That's all.
Okay, thank you. All right, if there are no other concerns or questions, if we could entertain someone reading the motion.
Chairman, before I do have a question about, okay. I was looking through quick and I couldn't find, I know it says to follow the CDC guidelines, but in the event that a year and a half from now, will this have to be revisited if COVID is not a concern any longer? In that it will be in the policy or in there, as the instructors would have to follow that. I'm just maybe wishful thinking, but what if if it's not there, then are they going to have to do that? That's my only concern.
From my standpoint, I think we'll revisit it, as the pandemic persists or hopefully ends. We can certainly I don't know if it would necessarily take council action, but we can certainly notify agencies saying, hey, you can ease up on some of these safety protocols. Generally in RBT, the equipment is cleaned anyway, just because people are wearing, the headgear and all that stuff. These just sort of, a lot of these protocols go along with what we're already doing. We're already doing because that's just the nature of training. We're already cleaning gear just because who wants to put on a sweaty helmet after you've already had it on and stuff.
Right.
So a lot of them are already in place. And then we can just, send out a notification or just update the council on the status of these protocols, as time goes on.
Okay, that's fine. And I understand that a lot of it is, you're absolutely right. A lot of it is just hygiene cleaning anyways that needs to be done anyway. But the other stuff, the masks or the gloves, and in the event that hopefully optimistically at some point we don't have to do that. But and if that's the case, then that's okay. That answers my question.
Okay, thanks.
Molly, if I could just clarify one point. I think when we talk about sharing of equipment, we're just talking about sharing of the RBT equipment, just to clarify. We're not talking about, sharing of PPE. That's something I just want to make sure when we reference sharing of equipment in here for everybody, we're talking about sharing of RBT, not PPE.
Oh,
right.
Absolutely. I understand that. Yes. Yeah.
Right. Yes. The RBT gear is assigned at the beginning of training, and they're responsible for cleaning their own gear. And the PPE, for a DCJS course, we would supply, disposable masks and disposable gloves. And that way, if they leave the room or whatever, they can just throw them out and get a new one. So yes. And then anything that's shared would be, for example, if they're doing a scenario within a police car, obviously you're not going to bring in 20 different police cars for each student. So you would just clean, wipe down the inside of the car and stuff like that.
Okay, thank you. I'd like to reach out to Colonel Allen and Chief Corey to see if they've got any input on this at all. Rick, any concerns?
No concerns from our end. We obviously are in a little different boat with the equipment we use, as we're an in-house agency and everything. We're following the same CDC guidelines that you're putting in place here. PPEs are supplied by us to all of the trainees, and the gear is cleaned in between usage. Anything that does have to be shared, like headgear. So it's right along the same policies as we're using.
Okay, thank you. Thank you. Chief Corey, any issues?
Good morning. No, again, this pretty much aligns with everything that we've been doing, and we have a very busy academy right now. We have about 1,800 recruits in there, 3 overlapping classes. So, and again, but much like state police, right? I mean, we're the only agency using it. We've gone to great lengths with COVID precautions and limiting the interactions even between, groups of recruits and sanitizing everything, and pretty successfully based on the numbers that we're seeing in there. So no issues at all.
Okay, thank you, Chief. Appreciate it. Any other concerns? I'd entertain a motion from one of the members, please, to read.
I guess I'll read the longer one.
Okay, Chief.
A motion to endorse the reality-based training instructor and recruit training COVID safety protocols recommendations, and direct the Office of Public Safety to disseminate the recommendations to law enforcement training academies and agencies.
Okay, I will second that, and then we'll seek Chief Breezy. How do you vote?
Yes.
Dr. McBride?
Yes.
And Dr. Klofus?
Yes.
Okay, thank you all, and that motion is carried on those safety protocols. Molly, thank you very much.
Chairman, did you vote as well?
I did vote, yes. My vote is yes. Thank you.
Sorry, thank you.
I certainly thought it if I didn't say it, so I apologize. And Molly, if you'd thank Mike for us, we appreciate his input on that.
Welcome. Thanks.
Okay, now we have regulation updates. Natasha, you're on.
Sure. Hello, Chairman and members of the council. I'm just going to update you on a couple of the regs. The first one is the hate crimes. I know I mentioned at the last meeting that they were in the process of being reviewed by Chamber, and they were adopted. So they're effective as of January 20th, 2021. So that's good news there. And then our use of force regulations. At the last meeting, I had mentioned that they were currently in the public comment period. We did not receive any comments this time around. So that's good news. I guess the legislature was happy with our amendments. So now they are ready to be officially adopted. They should be published shortly. And that's all I have.
Very good. Very good. Very good. All positive. Thank you, Natasha. The next is the police professional proposal, and Mike Green is going to present on that. Go ahead, Mike.
To make sure I get myself unmuted. So thank you, Sheriff. Appreciate it. As part of the governor's budget proposal, I think everyone's aware there's also legislation that goes with it, Article 7 legislation. And there are some pieces of legislation we thought were relevant for the council here. The first is a proposal that would create uniform hiring and training standards. The proposal would apply to municipal police agencies in the state, would require minimum hiring standards. I think we've discussed this before, but something as simple as a fingerprint-based criminal history check is not a legal requirement right now in terms of background process for hiring a police officer. So the proposal basically would have Mptc establish mandatory minimum hiring standards. Those standards would have to include things like criminal history check, medical provisions, physical and mental health provisions, background checks with regard to the good moral character provision that's in law right now but undefined. That would all be done through regulation. The proposal would then have the Law Enforcement Accreditation Council issue certificates of compliance to agencies that meet both the new Mptc established minimum hiring standards, as well as agencies who comply with the reporting obligations with regard to the reporting of misconduct to the Attorney General's office under the new Executive Law 75 provisions, and also agencies that comply with their registry reporting requirements under Executive Law 845. That would be separate and apart from the voluntary accreditation process that the Accreditation Council oversees now. Officers who are working for agencies that don't meet those standards and don't get that Law Enforcement Accreditation Council certification would lose their police powers. So the definition of police officer and the police powers that go along with that would be tied to the agency having a certification from the Accreditation Council indicating that they meet those minimum standards with regard to hiring practices and reporting of misconduct and reporting to the registry. In terms of decertification, the proposal would strengthen the current decertification process. As I think most folks know, right now the process is based on local interpretation of an officer's removal for cause due to incompetence or misconduct. And when I finish, I know, we unfortunately have had some examples, that at least from my perspective, are pretty egregious in terms of officers who were removed for cause, but were not reported to us that way, were reported as straight removals. And this would tighten up that process and I think, deal with those situations. The first thing we do is removal for cause would be redefined in regulation. And the new definition would have specific conduct. In a lot of ways, that conduct would mirror what's in the reporting requirements in Section 75 of the executive law. That specific misconduct, when it leads to termination, would trigger the reporting requirements. It would still require police departments to report officers who are terminated for cause to DCJS, but hopefully the guidelines would be clearer and there'd be less subjectivity or interpretation involved. Agencies with investigatory power, such as the Attorney General, who now are both designated to and required to investigate police misconduct under certain situations, would be required to report their findings to DCJS with regard to complaints or case status. The proposal would also provide DCJS Commissioner with the authority to remove officers from the registry when, based on reliable hearsay, it appears that a police department did not correctly report or outright failed to report a removal. I think the example there, which at least to me illustrates the intent of that provision, is an officer who's convicted, and this was an actual situation that occurred. An officer was convicted by a jury after a jury trial of assault for assaulting someone while he was working as a police officer, unlawful imprisonment for imprisoning that person, and I believe it was offering a false instrument for filing, but it was another crime in connection with falsifying the police report about the incident. So a jury convicted the officer of those three charges, and the officer was allowed to backdate the resignation to the day before the verdict came in, and it was reported to us as just a straight resignation and not a removal for cause. That situation where the reliable hearsay would consist of a certificate of conviction from a court indicating the conviction, in that situation, it would allow DCJS to invalidate the training certificate, regardless of how the agency chose to report it to us. Another piece of the proposal, currently, even if something is properly reported to DCJS, so in that situation, if that had been reported to us as a removal for cause, and I didn't, DCJS had invalidated that officer's training certificate, currently under law, there's nothing to prevent that person from going back through the academy, getting a new training certificate, and getting rehired as a police officer. Under the proposal that's been put forward, if someone's training certificate is revoked because they were terminated for cause under the reasons set out in the proposal, you would not be eligible for a new training certificate. So basically couldn't work as a municipal police officer again in New York. In terms of changes to both the Mptc and the Accreditation Council, there are membership changes. So with regard to Mptc, it would make the superintendent of the state police an automatic, I shouldn't say automatic, but a required member of the council. That's not the case now. It would mandate representation by a chief from a department of 100 officers or more. It would mandate representation from a sheriff of a department of 100 sheriff's deputies or more. It would add a representative of the crime victims community or someone with crime victims voice. It would mandate a representative from a community with high numbers of police community interactions. It would mandate a member from a agency that employs peace officers. And it would mandate the appointment of an academic or someone in the academic field of criminal justice to the council. Yeah, and that, you know, we have now with John Clofus, but just, you know, rather than an optional thing to have, it would make it, you know, a requirement. So there would be a voice that would have to be on the council. With regard to the Accreditation Council, there'd be similar changes with regard to membership. It would again require the presence of a chief of department of 100 or more officers, a sheriff from a department of 100 or more sheriff's deputies, crime victim voice, and the community voice as well. And then the effective date for all of it would be 3 years after the bill was signed. I shouldn't say all of it. I'll have to go back through because I think my recollection was that there were different effective dates, but in any event, the entire package would be effective 3 years after it was signed. So that's a proposal in the governor's budget. Obviously, any proposal, you know, is subject to either, you know, being accepted or being cut out, you know, or being modified through the negotiation process. You know, so happy to answer questions now, and we'll certainly keep people updated, you know, in terms of the progress during the course of budget negotiations.
Thank you, Mike. One quick thought on the hiring standards. Was that just police officers, or does it also involve peace officers?
That's a good question. My recollection was police, but just to make sure I don't misspeak, I'll go back and take a look, and we can get back to you for sure on that. I'll get back to the whole council.
Oh, okay. All right. And then the other thought I had, the effective date of all this would be it's part of the budget proposal, so it would be 22-23.
Generally speaking, the budget is adopted March 31st or April 1st. You know, so it would be 3 years from that date before everything would be effective. Again, I'll go back and look, but my recollection is that certain parts of it took effect before then, but the parts, you know, where, you know, the council would have to adopt standards, and then every agency would have to incorporate those standards and, you know, get a certificate indicating they were in compliance. You know, it was envisioned that that would take some time, and I think that section was the 3-year section.
Okay. All right. Yeah, thank you, Mike. Any other council members have concerns?
If we could too, Sheriff, and I apologize, but it just, there was one good example Mike Wood had, and if you don't mind, I think it would be important for the council, you know, to hear some of the things that we're seeing at DCJS around the reporting right now, you know, to kind of give this some context. Sure.
Yeah, that'd be good.
Thanks, Mike, and thanks to the council. Just, you know, it's hard. It's unfortunate that we have to, you know, talk about these things, but we do have and maintain a list, and you know, we deal with municipalities, police executive staff around the state on a daily basis regarding these issues. And you know, we're limited. We just want to ensure that the registry is accurate and the reporting is done in a proper fashion. And as I said, we have a number of instances where it's quite clear to us that things were reported perhaps incorrectly, and we don't have any recourse. And I think that's really important for the profession because some of these folks do get rehired in different locations. But one particularly egregious situation I'll just bring to your attention really quickly. The fact pattern is a bit tricky, but as you may recall, the regulations regarding the current certification process went into effect in late 2016 and then amended in early 2017. But we had a situation where a police officer was, another one of these was arrested and convicted, had to do with falsifying police reports, and was convicted of official misconduct. Since it was prior to the regulations and they didn't go backwards, the individual could not be reported as a removal for cause. However, which is not uncommon in certain areas of the state, I'm sure as you know, that there can be co-employment issues. You'll have certain officers who work in multiple agencies. So this particular individual was also a part-time employee in another village police department. The village became aware of the conviction, the investigation and conviction was in the same region, and acted within their town council on a resolution to terminate the officer as a result of that, which they did. This is several years ago. I can just tell you that to this day, and we've had conversations as recently in the last month or so with this particular town, that they continue to refuse to report that individual as a removal for cause. And we rely solely upon their reporting. It's pretty clear to us in the current regulation, statute, and regulatory framework that a town law resolution for a termination is very clearly within the guidelines for a removal for cause. So other interesting pieces in it. So what are the ramifications for that? So what ends up happening is this all develops, the individual seeks and gets full-time employment in yet another town police department. The police executive chief has strongly defended the hire on multiple occasions. It's public. I don't want to bring up names or agencies or anything. It's not important. It's just a fact pattern. Has continued to defend, and the entire town had deferred to the police, the chief's unilateral authority regarding hiring. And the council, I would just say, is quite familiar with this particular individual as well. Further complicating matters there and bothersome to me is that the original executive, where the criminal conduct occurred, where the officer was arrested and convicted, that individual in turn wrote a letter of recommendation for this person's hire at another police department. And then most recently, within about a month or so ago, this individual has now joined yet another police department, town and village. Again, local, we understand the local hire and home rule, but again, as we go down this road with regard to police misconduct and integrity and all these other issues that we deal with, and I wish I could sit here and tell this council that, that was just one occurrence. It's a particular egregious fact pattern, in my opinion, my personal opinion. But we have a number of these statewide where we believe that the current regulations are subject to such interpretation that people are not reporting things. Some of them are very clear to us, but others are subject to interpretation. And part of the proposal here would close up some of those loopholes, and with the most egregious circumstances that the commissioner, based upon, as he mentioned in the proposal, reliable hearsay, being convictions, town resolutions, a number of other matters where it was reported incorrectly, could just remove the individual from the registry. So again, thanks for listening to that. I just think it's important for everybody at your level within the policing profession to understand some of the things that are going on in New York State with regard to police reporting misconduct.
Thanks, Mike. And we struggle with the reporting, and again, I think it's important for the council to understand. We had one example recently where we read in the newspaper that a police officer was arrested. And when we checked the registry, and the police officer who was arrested was acting as the head of the police agency. And when we checked the registry, he wasn't even registered with us. He'd never been reported to us as even working for that department. So, the reporting issues and really putting a focus on those and getting that cleaned up, from our perspective, is very important. So I'll leave it at that. Thank you, Sheriff. Appreciate it.
Yeah. Thank you, Mike and Mike. Appreciate it. Any other council member concerns?
Bruce McBride. Commissioner, this really has great impact on the operations of DCJS and the Office of Public Safety. And also it kind of changes the whole role of the Accreditation Council, because it appears that the department has to be accredited. If they're not accredited, then they can't do anything. Is that pretty much an accurate reading?
We purposely got them not to use the word accreditation in connection with this process because we didn't want to mix the two. There was an initial version where they were calling both of them accreditation. We just felt that, first of all, it would water down what we think is a very good accreditation process that we have right now, even though unfortunately it's voluntary. So basically what it is going to change the function of the Accreditation Council by adding a second responsibility to it. And that second responsibility is referred to as certification. And that would be mandatory, would apply to every department. And the certification basically would cover hiring standards, reporting to the registry, including, reporting for misconduct, but also accurately reporting, who's hired and who's, removed and, who the officers are. And then also, let me just pull it up here so I don't misspeak. So yeah, it would include the hiring standards, reporting of misconduct to the Attorney General under the executive law, and reporting to DCJS and meeting registry requirements. Those three would make up a new certification, and agencies would have to comply with those requirements in order to get the Accreditation Council certification. And if they don't have that certification, then the officers working for that department would not be defined as police officers anymore by law, and wouldn't have police powers. So that will greatly add to the council's responsibility, in my opinion, and that first of all, will apply to every municipal police department in the state. Much more limited in scope, obviously, than the current accreditation program with its, I think, 109 or 110 standards. But still will require a process, and it will definitely add to the work of the Office of Public Safety as well, because, as the staff arm working with the council, we're going to have to put if it's adopted, we'll have to put a process in place, to make sure that those certifications, that the council and we have a way to know that folks are actually complying, before those certificates are issued. So I don't know if that clarifies it at all, or if I just confused it even more.
No, this is very helpful, and I promise to use certification. Thank you.
This is a kind of an odd question. Is there any talk or any thought about automating, meaning the current certificate or certification that has the signature of the county personnel or civil service personnel, the village entity for the oath of office, the chief? Is there any possible anything going forward with incorporating maybe that certification somehow into the Accreditation system?
I'll kick that over to Mike or whoever he wants to kick it to, but good question.
I know there's stuff going on. Johanna may want to go a little more specifically as far as some of our plans, but I think we require those things anyway. So I'm not entirely, we're working to try to be able to put documents into that system, the actual documents itself. But if I recall correctly, I believe we do get those documents right now. Anyway, Johanna?
Yeah, we do get those right now, as you indicated, Chief Parisi, in paper form, and we are looking to try to expand our system with Accreditation to try to enable it to get that electronically. It's something we're in current conversations about.
Okay, because it's kind of the last piece. You've got the registry through e-justice, and which is great, and you've got most of the other stuff with the Accreditation now automated. That would be the last piece. Understanding there's several entities that are certifying there, but that would be a nice addition, assisting that last piece of paperless. So thank you.
Yes, hopefully we'll get there, but we're working on it right now.
Okay. Thank you, Johanna and Chief. Any other concerns or questions? Okay, thanks again, Mike, for that report. Appreciate it.
Thank you.
All right, the next on the agenda is the mandatory recording of juvenile custodial interrogations. I believe we have a model policy regarding that, so maybe that'll be affected as well. But Josh is going to update us on that. Josh?
Thank you, Chairman. Yeah, last but not least, in regards to the informational items on the agenda, I just wanted to bring it to the council's attention that the laws of, well, first of all, that there's been a recently signed bill by the governor that will change the mandatory recording of juvenile interrogations. But just to give a brief background of where we are and where we need to go, because the effective date of this new law is November 1st, 2021. Just as a reminder to the council, back in 2017, laws were amended which established which offenses are mandatory for recording for both adults and juveniles. And it established that there was a certain class of serious offenses, Class A1 felonies, other than controlled substances, certain Class B felonies, and predatory sex offenses under the penal law were delineated in the piece of legislation in 2017 that were had to be recorded for both adults and juveniles. Later on, in June of 2018, Mptc updated their recording of custodial interrogations model policy and included these mandatory offenses that are to be recorded for both adults and juveniles in the model policy. And part of the amendments to the criminal procedural law of 60.45, it required DCJS to require DCJS to establish standards for the recording of custodial interrogations. And based on the amount of work that went into establishing the Mptc model policy as a best practice standard, the input we received from key stakeholders around the state and the body of research that we reviewed at a national level, DCJS felt it was appropriate to adopt the Mptc recording custodial interrogations model policy as the standard for agencies to follow. So fast forward now to the laws of 2020. As I mentioned, were recently amended, specifically the Family Court Act, to expand the recording requirements to all crimes by requiring video recording of interrogations of accused juvenile delinquents, meaning any crime, regardless of its classification, for juveniles would now be mandated to be recorded. The delineated offenses for adults would remain, but all interrogations of juveniles, regardless of the offense, will now need to be recorded, and it'll be effective November 1st, 2021. I say that to inform the council of this upcoming change to the law and the effective date, as this obviously will impact operations of law enforcement, but this also impacts the Mptc's model policy too, that we'll need to update that prior to November 1st. And obviously the quarterly meetings fall outside of November 1st. So we'll probably be looking to present it to the council in either June or September, the amended model policy to include this new requirement. Obviously, we'll have to footnote it and make sure that agencies are aware that this new recording requirement is effective November 1st, 2021. In addition, certainly I believe that DCJS would also consider adopting, again, the Mptc model policy as the standard for agencies to follow pursuant to the CPL 60.45 requirement. So again, that was just in a brief nutshell, real quick. Just want to bring that to the council's attention, that this change will take effect, and it also will impact the model policy, and we plan to present the updates to the council regarding this change in future meetings. And additionally, this will be, again, as an update, we'll post it to the DCJS public website too, so the most current version is available to the public. Any questions on that?
No, thank you, Josh. It's another one of those examples of that when DCJS and MPTC, when we get out in front of some of these issues, some of these legal issues, especially with a model policy, we avoid legislation, and it's good that we're addressing this now. So, any council members have any questions for Josh? Okay, thank you. Thanks again, Josh. Appreciate it. Okay, can you hear me, Josh?
Sorry about that. I was on mute. Thank you.
Okay, yep. Well, thank you. We appreciate that. Okay, well, I guess we now will go to new business, and I just want to make a couple of remarks on some issues that have come up that I've been involved in as chairman since the December meeting. I've had inquiries regarding school resource officer training and issues around that. I appreciate Josh's help on some of these things that we've been discussing. We had concerns about the SFST training, whether the wet lab was still involved in that because of COVID. We had some inquiries I did from some academy directors regarding whether they could mandate vaccines for any new recruits, that type of thing. Some other questions about procedural justice and the principal policing, which DCJS has addressed with some recent trainings that are going on, and that's all great. Additionally, the most recent one I believe was there's a bill S4093 that is being sponsored. I don't think it has an assembly co-sponsor yet, that requires Mptc to do a model policy on children's sensitive arrest practices. And I know that Josh and I discussed that recently, where obviously the juvenile procedures on the arrest of juveniles really cover all of those types of issues really well that we currently have in our basic course for police officers now. So I guess we'll see where that goes. And then finally, the other thing that was recently has come up is in that Rochester Police Daniel Prude case. Apparently, the AG had said something about that police may need training in excited delirium. And that's one of those terms that not all entities recognize. I know that the State Commission of Correction Medical Review Board doesn't really recognize the term. So I'm not sure where that's going to go, but I'm sure it'll be on OPS radar as we go forward. Any other council members have anything else they want to discuss under new business? Josh, anything else on your part?
I have nothing further to add. Thank you.
Okay. All right. Well, thank you all very much, and I will entertain I guess we'll entertain a motion to adjourn. Our next meeting would be June 2nd of this year, and look forward to meeting again. And I would entertain a motion to adjourn.
So moved, Bruce McBride.
Thank you, Dr. McBride. And second, Chief Parisi. And I believe we have to vote on this separately. I guess we do. Myself votes yes. Chief Parisi.
Yes.
Dr. McBride.
Yes.
And Dr. Klofus.
Yes.
Okay, then we are in adjournment. And thank you all very much for all the contributions and all the work that went into not only the action items, but the information items that were discussed today. This meeting is adjourned. Thank you.
Sheriff, thank you to you and council members as well. We really appreciate all of your work.
Thank you, Mike.
Thank you, everybody.
Yep, thank you, Mike.
Everybody
Thank you,
stay
everyone.
safe.
Yep, take
Stay
care,
safe.
Joanna.
Thank you.